March 1983, Cheryl Arujo enters Big Dan's Tavern in New Bedford, Massachusetts. 4 hours later, she flees the bar, screaming, half naked. 4 men are accused of holding her down on a pool table and raping her repeatedly.
Who was responsible is still an open question.
March 1991, William Kennedy Smith meets Patricia Bowman at O'Bar, an after-hours club in Palm Beach, Florida. They return to the Kennedy family compound for a late-night swim. The next day, Bowman reports to the police that Smith forced her to the ground and raped her.
Date rape cases are, by nature, cloudy.
July 1991. During a rehearsal for the Miss Black America beauty pageant in Indianapolis, boxer Mike Tyson meets contestant Desiree Washington. Later that night, they end up back at his hotel room. 2 days later, Washington accuses Tyson of rape.
For some reason that nobody can really understand, we have this tendency to begin to blame the victim.
The crime of rape is controversial mainly because, as a society, we disagree about what constitutes a rape. And so, with each high-profile case, the nation shudders and strains to understand how and whether a rape has occurred.
Not guilty! Not guilty!
Indianapolis was the scene of one of the most famous of these cases. Every year, the city plays host to the country's largest convention celebrating the African-American community, the Indiana Black Expo. The festivities in the summer of 1991 drew prominent blacks from around the nation. The VIPs included Jesse Jackson and Mike Tyson. Former world heavyweight boxing champion Mike Tyson needed little introduction at any event. His fame was international.
He exudes charm and magnetism and devastation in the ring.
At the Black Expo, he was a superstar. All doors were open to him. And when he visited rehearsals for the Miss Black America pageant on July 18th, he was invited to take part in a group dance number. It was there that he met one of the contestants. He invited her out on a date. And 18-year-old Desiree Washington, Miss Black Rhode Island, gave him the number of her hotel room. Later that night at 1:30 a.m., Tyson called her from his limousine. His chauffeur would later testify that Tyson begged Washington to come out with him. She agreed, and a few minutes later joined him in his limo. The two rode back to the Canterbury Hotel, where Tyson was staying, and went up to his room, Suite 606. About an hour later, Washington left. Tyson's chauffeur drove her back to her hotel, less than a block away. The chauffeur would later say she looked shaken and upset. Tyson left town the next morning, and Washington resumed her pageant duties. But 2 days later, she placed a call to the Indianapolis 911 hotline. She told the operator she'd been raped, but she was afraid to file a report, she said, because the rapist was a celebrity. She didn't want people to think she was after his money. In the end, Washington agreed to make an official report. She identified the rapist as Mike Tyson. In September, Mike Tyson traveled to Indianapolis to appear before the grand jury. His promoter, boxing impresario Don King, went with him.
He's innocent.
But the grand jury decided there was enough evidence to send the case to trial. Tyson was indicted and booked on 1 count of rape and 3 counts of sexual misconduct. As Tyson held a news conference to insist that he was the victim, the story gathered momentum, driven by the political and emotional confusion that surround date rape trials, particularly one involving a celebrity.
And I make myself vulnerable because I'm among the common people all the time, because that's my frame of mind.
Pressure mounted for the boxer to postpone his scheduled November title bout against Evander Holyfield. Following an injury, Tyson did delay the fight, leaving room for the legal battle ahead. Meanwhile, supporters both for Tyson and for Washington lined up outside the courtroom.
Shame on you for blaming the victim.
Oh, is she a victim? He's a victim too. Look at that. You're victimizing him just like she was a victim. He's being raped right now. You're raping him with them posters.
Most of the news media refrain from using the name or face of an alleged rape victim because the trial often provokes deeply intimate investigations into an accuser's life. It is widely believed that revealing her identity will discourage other victims from coming forward.
Why do you have to ask me questions like that?
To have a recess, Ms. Baldwin? Nowhere was that issue more thoroughly explored than in the date rape trial of William Kennedy Smith in Palm Beach, Florida, just 2 months before the Tyson trial. The proceedings were shown nationally, so the accuser's face was blocked out by an electronic gray dot. Hiding in plain sight may have given her even more notoriety than appearing openly. More debate exploded when NBC News revealed her identity, and the New York Times followed suit.
Not guilty.
Smith was acquitted, largely because his story was believable, more so it seemed than his accuser, who appeared unstable and unreliable on the stand. Another hotly debated element of Smith's trial had been the exclusion by Judge Mary Lupo of 3 witnesses who claimed that Smith had tried to rape them in the past. Lupo ruled that the alleged prior assaults, which the women had not reported to the police, were unproven and would be unfairly persuasive to the jury. Lupo's decision gave Smith a protection which is normally guaranteed to accusers in rape trials. Defense attorneys are forbidden by laws known as rape shields to introduce testimony regarding an alleged victim's prior sexual history. Still, a skilled defense attorney can get information damaging to an accuser's credibility around a rape shield. But as details of the Tyson case emerged, the defense saw little room for embarrassing the alleged victim publicly. Desiree Washington had an impeccable record. A popular overachiever at her Rhode Island high school, she was a cheerleader and a Sunday school volunteer at her Baptist church. She would clearly be a challenge for those who would take up Tyson's defense. The Tyson and Smith trials not only made headlines around the world, they focused our attention on the taboo areas of intimacy, sex, and violence. And as often happens in rape trials, the Tyson case raised the troubling specter of race in the pursuit of American justice. Rape on Trial will return in a moment here on A&E. We now return to American justice. In the trial of Indiana versus Mike Tyson, as in most acquaintance rape cases, the accuser and the defendant were the only witnesses to the alleged attack. That meant that Desiree Washington's credibility was also on trial. So the task for prosecutor Greg Garrison was not only to present a believable story, he also had to defend the young woman's character against an all-out attack by the defense team.
She was a courageous kid.
At the head of that defense team was Vincent Fuller, a somber Washington attorney with a national reputation for thoroughness. Fuller's most famous success had been to convince a jury in 1980 that would-be Reagan assassin John Hinckley was insane. As jury selection began on January 27, 1992, both sides were already hard at work. Desiree Washington had gone willingly to Tyson's hotel room late at night, so Garrison tried to screen out those who might believe Washington was asking for it, that she should have known what might happen. He asked prospective jurors if someone who foolishly went into a dangerous neighborhood deserved to be robbed of their wallet.
Every time, uniformly, not just the 12 that sat, but almost everybody else we have. Well, that's ridiculous. You can see them; they sort of swell up, and I'm going, great. You know, that's what I want. That's what I want to hear. I want these people to recognize that improvidence in a victim, exposing themselves to harm, is not a defense to criminal behavior.
Washington testified the first day of the trial. Her very size seemed to be an argument for the prosecution. She was clearly half of Tyson's size, weighing around 100 pounds to his 200 plus. Another unspoken argument in her favor was Tyson's profession.
What I said to the jury was, this is one of the strongest men in the world. And it goes without saying, his own testimony, I am the former heavyweight champion of the world. I knock people out for a living.
Tyson's history was a remarkable one, a rags-to-riches tale from the ghetto. He grew up in a rough Brooklyn neighborhood where old friends like Sylvester Gittins said the boxer never forgot his roots.
Whenever he's in New York, he calls or he comes by. He was born here, he was raised here, and everybody loves him.
Street crime landed Tyson in a reformatory by the age of 13, but he was rescued by legendary boxing coach Cus D'Amato, who had heard of his fighting ability. Under D'Amato's stern and loving hand, Tyson quickly proved to be a boxing prodigy, as sparring partner Mike Jamison could affirm.
What does it feel like? Let's see. A couple of sledgehammers, you know, hitting you on each side. Michael's big virtue is he hits you with everything.
Tyson matured into a fierce and apparently unstoppable fighting machine. When D'Amato, whom Tyson adored, died in 1985, other managers took over the fighter's career. His training continued under Kevin Rooney.
You'll see excitement when he wins the championship, when he's the unified title holder. Then I'll be happy.
It wasn't long before Tyson reached that goal. On November 22nd, 1986, at age 20, Tyson became the youngest heavyweight champion in boxing history when he knocked out title holder Trevor Berbick. For more than 3 years after that, Tyson lived up to his fierce reputation, clearing the boxing ring of challenger after challenger. He said publicly that he knew the place for violence was the arena.
This is my job. I'm not going to go on the street and beat up anybody. You know, this is my business. Boxing is the hurt business.
But with well-publicized incidents like a 1988 Harlem brawl with boxer Mitch Green and domestic outbursts against then-wife Robin Givens, Tyson developed a reputation for taking his business outside the workplace.
I just want to be the best at what I do, and that's fighting. And I just want to conquer, conquer, conquer. Like Napoleon wanted to conquer, like Kublai Khan wanted to conquer. I want to conquer.
In Tokyo on February 11th, 1990, the reign ended when Tyson lost the heavyweight crown to James Buster Douglas. By the time of the Black Expo in July 1991, more than one boxing expert had suggested that at 24, Tyson might already be past his prime. But he was still a hero to millions, including Desiree Washington's father, as she now testified at the trial. Washington said that Tyson asked her for her number, that she was thrilled and gave it to him. When he called her later, at 1:30 in the morning, she said she'd hesitated, but that she got out of bed to go with him because she thought they were going to drop in at parties around Indianapolis.
His agenda was purposefully hidden from her behind the mantle of his celebrity. And it worked to a T on this young woman who's thinking, this is Mike Tyson, this is my dad's hero. I'm going to go out in a limousine and I'm going to go to these after parties with Mike Tyson. Boy, wait till my dad hears this. And I got my camera so that I can have pictures to prove it.
When she entered the limousine, she said, Tyson grabbed her and tried to kiss her. She said that she pulled back, but not before noticing that he had bad breath. Then she said, Tyson remarked he had to stop at his hotel room, so they went back to the Canterbury. The two went to Tyson's suite. As Washington told it, she was just waiting to leave. But after making small talk, Tyson suddenly changed the subject. "You're turning me on," he said. Washington testified that she had replied, "I don't know why you got me up here. I'm not like that." She went to the bathroom expecting to leave when she returned. Instead, she told the court, she found Tyson on the bed in his underwear. Saying only, "Come here," he grabbed her. Washington testified that resisting Tyson was like hitting a brick wall.
She said that he had grabbed her by her wrists this way and pinned her down, and just because of the way she was dressed, he took her jacket down off of her and then just grabbed her up here and just stripped her. He got the bustier, he got her jammed, and he got her panties all in one swipe.
Washington testified that after forcibly performing oral sex, Tyson penetrated her vaginally, that the pain was excruciating, and that throughout, she was pleading with him to stop. But according to her testimony, she was pinned. Tyson had his massive arm across her chest. Harvard Law School professor Alan Dershowitz, who is now Tyson's attorney, says there was no physical evidence to back up Washington's story.
If Mike Tyson had done that, she would have had bruised ribs, black and blue marks, and perhaps broken bones, and yet there was no external evidence consistent with rape, and the only internal evidence was consistent either with rape or with consensual sexual intercourse with a man with a large penis and a woman who had not borne children, which was the case here.
That internal evidence consisted of 2 genital abrasions found during a medical examination. A doctor for the prosecution testified that he had never seen such abrasions from consensual sex in more than 20,000 exams. Even a doctor for the defense testified that such abrasions were highly unusual.
These abrasions hurt. They hurt when they happened, and to continue the act of intercourse once the abrasion had occurred was extremely painful for the woman. Well, I'm thinking, that's pretty inconsistent with consensual sex.
On the stand, Tyson's version of the night was different in a few crucial ways. One key distinction was a conversation he said took place before the date, in which he made his intentions abundantly clear. Tyson told the court that while chatting with Washington at the pageant, he had used a common 4-letter word to describe to her what he wanted to do on their date. According to the boxer, Washington had told him to call anyway. As for the ride in the limo, Tyson testified that he and Washington had been kissing and hugging willingly. Then, when they got to the hotel room, it was she who was, as he put it, moving fast. She took her clothes off first.
In the middle of the sex act, he said to her, "Now would you like to get on top?" And this is her own testimony, and she said, "Yeah, I would," without explaining why she wanted to get on top. She later told the jury she wanted to get on top because it would make it easier for her to run away, which she didn't do.
She never told me to stop, Tyson said on the stand. She never said no. As for her outrage, Tyson suggested it began after their sexual encounter.
Mike made a terrible mistake. He didn't walk her to the car. He didn't kiss her goodnight. He just basically treated her like a one-night stand. She got very upset, came back to her hotel, told a variety of stories, said, "I think he tried to rape me, maybe he raped me, he did it on the floor, he did it on the bed." The story is totally inconsistent.
The case would hinge on these two versions of the night's events. Every other witness and any evidence introduced was meant to shore up one narrative or the other. The prosecution presented witnesses, including Washington's mother and her hotel roommates, who testified that the 18-year-old was naive and that her behavior had changed radically after the night of the 19th. The defense settled on the strategy of convincing the jury that Washington's proclaimed naivete about Tyson was inconceivable, not only because of his supposed lewd comment at the pageant, but because of his publicly crude behavior. Defense attorney Vincent Fuller produced witness after witness who testified that Tyson had grabbed their breasts and buttocks at the pageant or had made blatantly sexual remarks. He was clearly taking the risk of suggesting that Tyson's sexual appetite was so voracious he might disregard resistance. But the key was to discredit Washington's story of innocent gullibility. And even the prosecutor felt that Fuller had no choice, since Tyson's coarseness was bound to come out in the trial sooner or later.
An old axiom in the criminal law, really in any trial practice, that if there's bad stuff to come out against your side, you be sure you tell the story. So you think, okay, fine, take the bull by the horns. This is a young man who makes no bones about, no excuses about his sexual preferences and his appetites, so let's try to make the best out of that.
What I think Vince Fuller was trying to do was to persuade the jury that Desiree Washington knew exactly what she was getting into when she went to Mike Tyson's hotel room at 2 o'clock in the morning, responding to his phone call at 1:30 in the morning, that there was a sexual tension, a sexual atmosphere surrounding the entire pageant.
The defense also tried to put on 3 witnesses who had claimed they'd seen the couple kissing in the lobby of Tyson's hotel that night. But the judge excluded the 3 because they were not produced until the prosecution had almost rested its case. Judge Patricia Gifford also barred Tyson's limo driver, prosecution witness Virginia Foster, from testifying that Tyson had attacked her the day before.
My argument was, Judge, this is a thumbprint. This is the same signature over again. Get them into a room by themselves. Close the door behind them. Come in, I want to talk to you. Now you're turning me on. Just like that.
Tyson withstood an hour-long cross-examination at the hands of prosecutor Greg Garrison. Garrison focused on inconsistencies between Tyson's trial testimony and his previous grand jury testimony. Before the grand jury, Tyson had not said he used a 4-letter word to Washington.
I said, I want to be me and you. I want to be with you alone. I said, I want you.
You said, I want to be me and you alone.
Yeah.
I want you.
Yeah.
What did she say?
She said, okay, just call me.
Garrison did his best to corner Tyson on that particular point.
He made a good witness in terms of being totally adequate to joust with me mentally. I mean, I did not feel as though I was talking to some stupid guy that I was going to fox into a corner. Wasn't that way at all. I did have the luxury of cross-examining a guilty defendant who was stuck with his own misdeeds, and that hurt him bad.
The jury retired on February 10th. After 9 hours of deliberation, they agreed with Garrison. Mike Tyson was found guilty of rape and 2 counts of sexual misconduct. Tyson was sentenced to 10 years with a 4-year suspension, meaning he had to serve 6. But the trial was only the first round. Parts of the Indianapolis proceedings would be the grounds for Tyson's appeal, as would the claim that his accuser had perjured herself on the stand. American justice will return in a moment with Rape on Trial. We now return to Rape on Trial here on A&E. Mike Tyson began his 6-year sentence for the rape of Desiree Washington on March 26, 1992. But even as he was frisked and fingerprinted, his appeal was already underway. Legal scholar Alan Dershowitz, famous for defending such high-profile clients as Leona Helmsley and Klaus von Bülow, picked up Tyson's appeal and brought his trademark sense of drama to the case.
Every minute that Mr. Tyson is in confinement is a minute of injustice.
One key point in the appeal was the exclusion of defense witnesses who had planned to testify that they had seen Tyson and Washington kissing in the lobby of the Canterbury Hotel. Judge Patricia Gifford had excluded them on the grounds that they had been produced late in the trial.
This judge, handpicked by the prosecution, excluded 3 witnesses who saw Desiree Washington engaged in sexual foreplay with Mike Tyson just 5 minutes before the hotel door closed behind them.
As Tyson began life at Plainfield Prison, Dershowitz charged that through a quirk in Indiana law, the state had picked Gifford because, as a former sex crimes prosecutor, she would be sympathetic to the case against Tyson. Greg Garrison insists these charges are untrue. He also says the witnesses would not have helped the defense, that the woman they saw was singer BNGB, who also attended the expo.
These are not credible people. They get the color of the limousine wrong. Interestingly enough, one of them called it a white limo. Well, the night before the rape occurred, Tyson is at the hotel in a white limousine with Angela Boyd, BNGB. And according to the limo driver, they were all over each other.
The case was riddled with disputes, including an accusation of perjury. After the trial, Desiree Washington filed a civil suit for an unspecified amount in damages from Tyson. On the stand, she had suggested that she had no contract with an attorney to pursue civil charges. But in June of 1992, the court learned that wasn't the whole truth. She had signed such a contract with a previous lawyer. 4 jurors later told reporters they might have voted differently had they known at the time she was going to file a lawsuit.
We know our judicial system is not perfect, and I still feel it's a good system, but sometimes you make mistakes, and I think we all feel like that there's been a mistake made somewhere here.
But Tyson was not granted a new trial on the basis of this dispute, and his appeal was denied in August 1993. Bringing civil suit in rape cases, as Desiree Washington did, is a growing trend. It can also often backfire. Linda Fairstein is chief of Manhattan's Sex Crimes Prosecution Unit and author of Sexual Violence, Our War on Rape. She recalls a case where an appeals court overturned a rape conviction because of a civil suit. During the trial, the prosecution had defended the claims of the accuser by asserting she had no reason to lie.
The day after the conviction in the criminal case, the victim filed a lawsuit, and it was an $8 million lawsuit. Our Court of Appeals reversed the conviction of the defendant, claiming that the victim had 8 million reasons to lie, 1 for every dollar she tried to get.
The Tyson case is a clear reminder that it's an advantage for the prosecution if the accuser presents an unblemished history. Rape shield laws exist to protect the victim from having her sexual history used as evidence. Mike Tyson. His supporters argue that the defendant was just one more black man vilified by a white system.
What's the difference between the Mike Tyson case and the William Kennedy Smith? Right. Why was he only innocent? That's right, he's black.
Mike Tyson, tragically, was the stereotype that many racists hold in this country. A young, black, sexually active, athletic, strong, uneducated, formally at least, young man, and it's what so many people fear in this country. So I think the stereotype hurt him.
Tyson's accuser was also black, but that did not deter groups such as the National Baptist Conference from supporting Tyson on racial grounds.
Mike Tyson comes before me as a black male that has never really been given a chance.
I don't understand where that comes from. When you have a same race scenario with white defendant, white victim, black defendant, black victim. Frankly, those who raise that specter and want to make this some kind of racial politics, what are they saying to the woman? You don't count?
And now the conclusion of Rape on Trial. Society's view of rape has undergone a transformation in the past 20 years. For example, The notion that a rape could be committed by a husband or a boyfriend was once given little credence. Not so today. Credit for raising American consciousness certainly goes to high-profile cases like the Mike Tyson and Big Dan's trials. But defense attorney Judith Lindahl warns that there are limits to the interpretation of any single trial.
The verdict in the Big Dan's case was not a repudiation of disgusting behavior. It was not a vindication of the rights of women to be free of attack or to be the objects of disdain in a patriarchal society. It was a simple verdict that said 4 of these men are proved guilty beyond a reasonable doubt.
But the Big Dan's trial is in fact held up as a symbolic vindication of all rape victims. It is a view still held by many, including author Susan Brownmiller.
It was a rape case writ large, and I think for very, very good reasons. It was like a Greek drama. Her lifestyle could not be used against her to such an extent that people couldn't see what happened on the pool table. That was a victory for justice and a victory for women.
Thanks to considerable changes in law enforcement practices and the entrance of more women into police forces, police are widely considered to be more sympathetic to victims of sexual assault than they were just a decade ago. Rape crisis centers, counseling, and legal advocacy are now commonplace. But the FBI still records over 100,000 reported rapes a year. Victims' organizations place the number of actual rapes 6 times higher. But all these statistics remain a subject of considerable dispute.
Rape is both the most underreported crime in America. It's also the most overreported and falsely reported crime in America. Both of those are problems. And we have to figure out ways of making the system more accurate, of making sure that real rapists are convicted, but that people who are falsely accused get a fair shot at justice.
Alan Dershowitz believes that Mike Tyson did not get a fair shot at justice in his 1992 Indianapolis trial. That because the judge was a former sex crimes prosecutor, Tyson was wrongly convicted. Prosecutor Greg Garrison sees it differently. For Garrison, the Tyson conviction was American justice at its finest, the system rewarding a victim brave enough to come forward and endure the indignities of public examination.
This she had it coming mentality is dreadfully dangerous. And it is one which we cannot, if we intend to be moral people and to be driven and governed by the rule of law, is one that we cannot abide. And I think that if we've struck a blow against that logic, then it was worth the energy.
But the she-had-it-coming mentality survives.
She raped herself.
It's a crime of violence. Anybody that knows anything about rape or sexual assault of any kind will tell you this is not a sex crime. That's a misnomer. It is a crime of violence, which is perpetrated sexually.
The individual is interested in the power and control that he can exercise over the victim, and sex becomes one of the most effective ways to do that. And he often is attempting to degrade or humiliate the victim.
It is in order to prevent further humiliation that the news media refrain from identifying accusers. But there are those who believe that practice has the opposite effect.
That adds to that historic shame about being a rape victim. I feel we'll move further along if the names of both the victims and the perpetrators / defendants are made public like they are in other kinds of trials.
But shame is not the only outcome of a rape. Experts have long argued that the threat against a victim's life, whether implicit or explicit, is a major factor in the crime.
Women are terrified of losing their life in a rape case, and in addition to the old fears that, he's going to just stick the knife in my chest, the new fear is there can be this delayed time bomb. He could be infected, HIV positive.
AIDS has brought new complexities to the task of prosecuting rape. In October 1992, Elizabeth Wilson brought charges against Joel Valdez. She said that Valdez had broken into her home in Austin, Texas, and raped her at knife point. But then Wilson told the grand jury what she had said when she called the police, that she had asked Valdez to put on a condom to protect her from AIDS, and that he had done so. When the grand jury heard that, they refused to indict Valdez. As they saw it, Wilson's request that the man put on a condom amounted to consent. Following tremendous popular outcry, Valdez was indicted by another grand jury and eventually convicted of rape. But the Valdez case is a textbook example of why so many women don't report rape. The fear, whether in the police station or on the witness stand, that they will not be believed. It's a powerful reminder that, as a society, we bring our preconceptions about sexuality right into the courtroom, where they directly influence the way American justice is meted out. Rape remains such a frustrating issue because it trespasses on that intimate and often ambiguous ground. I'm Bill Curtis. Join us next time for another edition of American Justice here on A&E.
Is the death penalty inhumane, or does the punishment fit the crime?
It's a tough issue.
It is. Bill Curtis hosts Execution at Midnight, Friday on Investigative Reports.
Now, why was the D-Day invasion so successful?
We'll take a look at the world's most famous land and sea assaults on our century, next on A&E.
It's time well spent.